राष्ट्रीय न्यायिक सेवा प्राधिकरण
न्यायालयातल्या कारवाई खातीर बरो वकील मेळून दिता.
वेळार योग्य कायदा खालची मदत आणि सल्लो दिता.
लोक अदालत द्वारा चढ काळच्या केसीक बेगीन सोपयता.
आणि ते बी सामके मोफत.
राष्ट्रीय न्यायिक सेवा प्राधिकरण बेस बरो न्याय बेस बरो समाज.
अधिक माहिती खातीर लागच्या न्यायालयातल्या न्यायिक सेवा प्राधिकरण कार्यालया लागी संपर्क करा
वा टोल फ्री नंबर 15100 चेर फोन करा.
I am Advocate Jay Savaikar and it is my pleasure to welcome you to Goa State Legal Services Authority's Virtual Juridicare Series. Today we have brought to you a very important topic since conflict or family quarrel has caused the breakdown of joint family system. Conflicts regarding family property, its income and expenditure, unequal distribution of work at home and personal clashes between men and women led to the breakup of families. We have with us Advocate Ketaki Pednekar who will give us insights of divorce, annulment and its effects upon the marital estate of the spouses.
The perception of marriage differs among people due to their religious beliefs. Each religion has its own personal laws governing marriages and their dissolution. Some consider marriage as an indissoluble union until eternity, whilst others look at it as a civil contract between the spouses. The government of India has enacted various procedural enactments such as the Hindu Marriage Act, the Special Marriage Act, the Parsi Marriage and Divorce Act, the Dissolution of Muslim Marriage Act, the Divorce Act, etc., in respect of marriages and their dissolution in alignment with the personal laws of the parties. Though the Government of India has failed to enact a uniform civil code across India as mandated by Article 44 of the Constitution of India, the 451-year-long Portuguese governance in India has made it possible to have a civil code of 1867 which ensured that a uniform law applied to all the people of Goan origin in respect of marriage and succession. With passage of time and in response to the dynamic social and political conditions, various new enactments like Law of Marriage 1910, Law of Divorce 1910, Code of Civil Registration 1912, Code of Civil Procedure 1939, etc. were enacted, repealing portions of the Civil Code expressly or impliedly. When Goa was liberated, the Parliament thought it fit that the laws enacted during the Portuguese rule governing the people of Goa in respect of their marriage, divorce and succession, etc. should continue to remain in force, and accordingly, the various personal laws in force in the rest of India were not extended to the state of Goa. What is important is understanding that Goan laws are applicable only to persons of Goan origin. Simply stated, a person of Goan origin is someone who, or either of whose parents, or any of whose grandparents were born before the 20th December of 1961 in the territory of Goa. The Civil Code, following the well-established principle of private international law, states that law of the male spouse shall govern the marriage of the couple, which leads us to two corollaries. A. That when the husband is of Goan origin and the wife is non-Goan, then their marriage, separation and marital estate is governed by the Goan laws. However, when the husband is a non-Goan, then even if the wife is of Goan origin, their marriage, separation and the marital estate is governed by personal laws of the husband. When two persons of Goan origin get married, the Civil Code and other laws in force in Goa govern their marriage, separation and distribution of marital estate of the separated spouses. Likewise, when two non-Goans get married in Goa, their own personal law will govern the marriage, separation and distribution of their marital estate. The Civil Code of 1867 and other laws in force in Goa will not apply to or govern such a marriage. Marriage as defined under the Goan law is a perpetual contract made between two persons of different sex with the purpose of legitimately constituting a family. Therefore, all prerequisites of a valid contract are applicable to a marriage between two Goans in order for it to be treated as a valid and subsisting marriage. Requirements such as contracting parties being measured in age, consensus of the parties to contract marriage without coercion, the marriage contract not being contrary to the requirements of law and public policy, etc., have to be necessarily complied with. Any lacuna or fulfillment of these requirements will give rise to nullity of marriage. The marriage has to be solemnized before the officials of the civil registration under the conditions and manner prescribed in the Code of Civil Registration. As mentioned before, the Portuguese Civil Code treats marriage as a perpetual contract. Therefore, originally, prior to 1910, the Civil Code did not permit divorce or annulment. A marriage ended only when one of the parties to the marriage died. In 1910, the law of marriage was enacted to deal with marriages and annulments, while the law of divorce 1910 was enacted to deal with divorces. This was for the first time that dissolution of marriage, including divorce by mutual consent, came to be permitted. In 1939, the Code of Civil Procedure was enacted, and the same contained new provisions dealing with divorce by mutual consent, thereby revealing those provisions of the divorce by mutual consent contained in the Law of Divorce 1910. Thereafter, in 1940, the Portuguese government entered into a treaty with the Vatican, commonly known as the Concordat. Pursuant to this treaty, the Decree number 35461 of 25th of July 1940 was enacted to deal with marriages in the Portuguese colonies. The decree recognized Catholic or canonical marriages and held the same to be indissoluble. Further, it recognized the civil effects of marriage celebrated in conformity with the canonical laws, provided the record of the marriage was transcribed in competent civil registers. Two Catholics that married under the canonical law could not divorce, but two Catholics married before the civil registrar could divorce. Under Article 19 of the said decree, a canonical marriage annulled by a canonical tribunal was recognized, and such annulments were given legal effect to. In the year 1974, the Judicial Commissioners Court struck down Article 4 of the Law of Canonical Marriages, which did not permit Catholics who married canonically from getting divorced. Recently, the High Court of Bombay at Goa struck down Article 19 of the Decree number 35461 by its judgment dated 15th of October 2019, as the said provision reduced the status of the High Court to a post office conveying the decision of annulment of marriage taken by the church tribunals in Goa and Mumbai to the civil registrar with a direction to cancel the marriage registration. The High Court held that even under the canonical laws, marriage is a civil contract, and that the church patriarchal tribunals, while adjudicating grant of annulments, were amenable to natural principles of justice and procedures laid down under the Civil Code. Article 19 was struck down mainly because it provided that the church patriarchal tribunals with exclusive jurisdiction to deal with annulment under the canonical law and thereby precluded the High Court from judicially reviewing the decisions of the church patriarchal tribunals. This decision, passed in writ petition number 351 of 2017 by the High Court of Bombay at Goa, discusses various provisions regarding dissolution of marriage under the Portuguese law. The said decision of the High Court of Bombay at Goa is presently under challenge in the Supreme Court of India. Therefore, from the above discourse, it is clear that the marriages solemnized under the Portuguese law can be dissolved by A. Annulment of marriage, B. Divorce by the spouses, or death of either of the spouses. Broadly speaking, the difference between an annulment and divorce is that annulment is a process by which a marriage is declared null and void due to grounds that existed prior to the marriage or at the time of entering into the marriage. Divorce, on the other hand, is a process by which a marriage is declared null and void due to grounds that have arisen after the parties entered into marriage. Let us now consider both these processes slightly more in detail. When a marriage is prohibited or is contracted in violation of legal requirements, then the marriage is null and void or voidable by the mere operation of law, and it is as if the marriage never existed. Void marriages are marriages which are treated as if they never existed due to the fact that the parties contracting these marriages could never have entered into such a marriage. The following marriages are considered as void and treated as if they never existed. Marriage among relatives by consanguinity or affinity in a direct line, although the marriage which caused the affinity has been dissolved, are prohibited. Examples of marriage among relatives by consanguinity are marriages between direct relatives such as father and daughter, grandfather and granddaughter, mother and son, grandmother and grandson, etc. Affinity, on the other hand, means a relationship which is created out of someone else's marriage. Example of marriage by affinity are marriage in direct line between an aunt and her nephew, that is former husband's brother's son. Marriage between legitimate or illegitimate brothers and sisters by full blood, consanguineous or uterine are prohibited. Marriage between a male below the age of 18 years and a female below the age of 16 years is prohibited. Marriage with a person who is suffering from disability due to insanity or found suffering from an incurable or contagious disease, or of an incurable disease involving sexual abnormality is prohibited. A marriage between two persons who have been convicted of committing murder or abetting commission of, or of attempt to commit murder of the other spouse is prohibited. A marriage between those joined by another marriage which is not yet dissolved is forbidden. A voidable marriage, on the other hand, is the one which is valid but which can be cancelled on account of violation of certain grounds that existed prior to the marriage or at the time of entering into the marriage. A voidable marriage is valid but is subject to cancellation if contested and so proven in the court of law by one of the parties to the marriage. Marriages are voidable if they are contracted on violation of following grounds: males above 18 years of age and females above 16 years of age but below 21 years of age and who are not emancipated are prohibited to marry without the consent of their parents or persons responsible for them. Annulment of such marriage can be obtained by the spouse within 6 months from attaining majority, or in case of a person whose consent was necessary for solemnization of marriage, within 6 months from the date of solemnization of such a marriage. Also, marriages where consent of the contracting parties is proved to have been caused by mistake or by coercion are considered voidable. Consent by mistake is relevant only if it relates to the person with whom the marriage is contracted and shall be based on ignorance of his or her status and or ignorance of a non-bailable offence not barred by limitation and committed by him or her before the marriage, and or ignorance of previous physical defect like impotency and any incurable disease, contagious or hereditary. Consent by coercion consists of a threat of serious and imminent danger to the life or honor of the coerced spouse or to that of his or her relatives by lineal consanguinity or up to 4th degree in collateral line. Annulment of marriage on the ground of consent by mistake is barred by limitation after 1 year from the date on which party under mistake had knowledge, while annulment of marriage on the ground of consent by coercion is barred by limitation after 1 year from the date on which coercion ceased to exist. The important point to be noted is that limitation period for filing such a petition for annulment on the ground of consent by mistake or consent by coercion is 1 year from date of knowledge or cessation of coercion and not 1 year from the date of marriage. The petition seeking declaration of nullity of a marriage can be filed by a person having interest therein. Even a public prosecutor can seek annulment of a marriage as soon as he becomes aware of such a nullity. Divorce is a process of dissolution of a legally valid marriage. Now let's discuss divorce as a process of dissolution of marriage. Divorce is a process of dissolution of a legally valid marriage. A marriage which is contracted, abiding all the provisions of law, is a valid marriage. There are two kinds of divorces under Goan law. The first is a contested divorce, and the second is a divorce by mutual consent. A contested divorce is a divorce which is filed by one of the parties to the marriage on account of certain grounds that have arisen after the marriage is contracted. Under the Goan law, a decree of divorce can be obtained on the following grounds: adultery committed by the wife, adultery committed by the husband, final conviction of one of the spouses to undergo any of the major penalties, ill treatment of serious injuries, complete abandonment of conjugal domicile for a period of not less than 3 years, absence when nothing has been heard of the absentee for a period of not less than 4 years, incurable unsoundness of mind when at least 3 years have lapsed after its pronouncement by judgment, and such a judgment has not been challenged or appealed against, de facto separation, freely consented for 10 consecutive years, whatever may have been the cause of that separation, chronic vice of gambling, contagious disease found incurable, or an incurable disease involving sexual abnormality. The grounds upon which the divorce is prayed for have to be stated clearly and precisely in the petition. Any ambiguity in that context results into the rejection of the petition. The grounds for divorce sought for have to be proven by reading evidence similar to a normal civil suit. Divorce by mutual consent, on the other hand, is one in which both spouses file a petition seeking a decree of divorce jointly. A divorce by mutual consent can be petitioned only by spouses who have been married for over 5 years and where both the spouses are over 25 years of age. The parties seeking a divorce by mutual consent have also to file an agreement reached by them with respect to the custody of their children, maintenance of the children, division of the marital estate, etc. After the petition for divorce by mutual consent is filed, the judge shall summon the parties for a first meeting and attempt reconciliation among them. If the reconciliation fails, then the court shall grant provisional decree of divorce for a period of 1 year. The provisional divorce suspends the obligations of the spouses to live together. After lapse of 1 year, the parties shall appear before the judge for a second meeting. If the spouses agree on reconciliation, then the provisional divorce is declared as void. However, if the spouses fail to agree on reconciliation, the court shall record such a failure of conciliation and pass judgment and decree finalizing the divorce. Now let us come to the effect of an annulment or a divorce proceeding on the properties of the spouses. Most people are under the impression that if their marriage is annulled on account of its being void or voidable, or if a decree of divorce is granted in a contested matter, then the properties brought by the couple into the marriage revert to the ownership of the spouse which brought the property into the marriage. This is not always the case. Even though a marriage may be dissolved by a decree of annulment or divorce, there are civil effects which continue. In absence of the contracting parties entering into a prenuptial agreement prior to the contracting of their marriage, the default regime of marriage governing the assets of the couple is that of communion of assets. For example, A gets married to B. B owns a house. In the absence of a prenuptial agreement, A becomes the co-owner of the house upon her marriage to B. Now suppose A and B get their marriage annulled or get divorced. What happens to the house? The common misconception of law is that the house once again becomes the absolute ownership of B and A has no share in the said house. This is wrong. Article 30 of the Law of Marriage states that when a marriage, null or voidable, is contracted in good faith, it will produce its civil effects in respect of the spouses. If only one of the spouses contracts in good faith, the marriage shall produce effects only in respect of him or her. Thus, Article 30 of Law of Marriages takes care of both voidable and void marriages. Therefore, even where there is an absolute nullity and that marriage is in fact annulled, the good faith of the spouses is considered, and the marriage produces its effect in respect of both, if both are in good faith, or in respect of that spouse who is in good faith, if only one is in good faith. An example of this is as follows. Suppose A married B. A might have been suffering from an incurable disease or impotency prior to his marriage to B. If A had knowledge of the same and still entered into the marriage without disclosing this fact to B, then B is entitled to ask for annulment of her marriage to A. Here, in this case, since A has knowledge of the same and still entered into the marriage without disclosing the fact to B, he did so in bad faith, and as such would not have any rights to the properties of B. B, on the other hand, would be entitled to rights in the properties of A as she had entered into the marriage in good faith. On the other hand, if A and B both did not have any knowledge that A suffered from impotency or an incurable disease prior to their marriage, then it can be said that both the parties entered into such a marriage in good faith, and as such would be entitled to have a share in the assets of each other. Article 69 of Law of Marriage provides that unless specifically regulated otherwise, an annulment of marriage or obtaining decree of divorce between the parties will have the same effect on their persons and assets as dissolution of marriage upon death. Therefore, in case of an annulment or a contested divorce, the parties have to then divide the assets belonging to them. This partition of marital estate can be carried out either by way of partition proceedings or by way of an inventory proceeding. Taking the same example as mentioned above, A and B can enter into a deed of partition executed and registered before the sub-registrar, whereby they divide the house, or by which they allot the house to one spouse and the other spouse is compensated in terms of money equal to the value of the house. Alternatively, A or B can file an inventory proceeding. The older of the two spouses is appointed as the head of the family and has to enlist the house as an asset. A or B can then ask that an auction be conducted in the inventory proceedings and bid for the same. The successful auction bidder then has to pay overty monies to the other party. In case of a mutual divorce, the parties have to be specific in the agreement that they enter into and file along with the petition as into the manner in which they have agreed to partition the assets. Therefore, it is essential to know that dissolution of marriage under the Portuguese law is not simpliciter separation of persons, but has legal and civil repercussions upon separation of properties as well. Hence, while obtaining a decree for divorce or annulment, it becomes essential that the entire process of separation of properties is followed to the last T. Otherwise, there will be legal complications that may arise.
Family is one of the most important, if not the most important thing in our lives. Taking time every day to appreciate your loved ones for all that they do help us to reconnect as a family. However, it may happen that relationships end for a wide variety of reasons. Conflict is one common reason, but sometimes it involves other reasons that mean ending a relationship with someone. Advocate Ketaki Pednekar has shown us how to deal with the marital estate of the spouses when this happens. Thank you for the valuable information you have shared, Advocate Ketaki. It's time to end today's session. Before parting, I request all the viewers to kindly like, share and subscribe to this channel. See you next week.
एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए, उल्लास न्याय का सबके लिए, विश्वास न्याय का सबके लिए।